She eloped with her brother. Yes, my lord. She eloped with her own brother-in-law. Our tangi gandan jotege odogirodu. It is not an absolute owner. She is not an absolute owner of the property. Back then, she was only 19 years old.
What were you doing for 17 years?
Lords, this is a DV proceeding, my lords, which is not
violence. ಆಯ್ತಾಯ್ತು ಗೊತ್ತಾಯ್ತು. ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ separate?
18 years of non-cohabitation.
It's covered by Supreme Court judgment where it says, Lordship, to see the para 15 of my petition, domestic violence petition, I've made a specific statement that my property husband, he forges my signature, he impersonates me.
When?
What's 19/5/2022. He impersonates me, gets a release deed executed.
From whom?
My property. He takes some other lady and says he's my wife, and he gets a release deed.
ಅದಕ್ಕೆ DV proceedings ಯಾಕೆ?
Economic abuse.
Crime register ಮಾಡಿ.
Lords, under a Domestic Violence Act.
Problem. I'm not saying it won't come. Why have you not registered a crime for forgery, impersonation?
That case is registered, but still the proceedings is maintainable. It's covered by Supreme Court judgment.
All right. Yeah.
Supreme Court judgment. It's covered.
Stress ಯಾಕೆ ಮಾಡ್ಕೊಂತೀರಾ? ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಕ್ವೆಶ್ಚನ್ ಅಷ್ಟೇ. ನೀವು ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಿರಲ್ವಾ?
Yes, that's independent proceedings. Case register ಆಗಿದೆ.
ಅಷ್ಟೇ ಕೇಳಿದ್ದೆ. ಅದು ಯಾವ ತರ ಪ್ರೊಸೀಡಿಂಗ್, ಏನ್ ನಿಮ್ಮ ಅಡ್ವೈಸ್ ನನಗೆ, ಅದೆಲ್ಲ ನಾನು ಕೇಳಲಿಲ್ಲ.
Yes. My lords, this is one case where there is a gray area, my lords. I'll be making some legal submission on one aspect. 2F and 2S.
We'll fill up the gray area. Yes.
That is what, my lords. My lords, when the very foundational aspect of 2F and 2S is not, it is not satisfied, the whole superstructure built on a foundation collapses, my lords. I'll explain, my lords. My lords, when the domestic, the 2F, my lords, I'll not trouble you a lot. 2F and 2S, but the main problem here is, my lords, the domestic relationship is it explains that at any point of time,
separated or divorced,
it was non-cohabitation. It's not separated. She has left me. The real fact is, my lords, I am not taken any action. Why? Because she left me by she eloped with her brother. Yes, my lord, she eloped with her own brother-in-law. If I say this outside, that
what do you mean own brother-in-law?
ಅವ್ರ ತಂಗಿ ಗಂಡನ್ ಜೊತೆಗೆ ಓಡೋಗಿರೋದು. ಇದನ್ನ ನಾನು ಹೇಳಕ್ ಹೋದ್ರೆ ನಂದು ಮರ್ಯಾದೆ ಹೋಗುತ್ತೆ, ಅವ್ರದ್ದು ಮರ್ಯಾದೆ ಹೋಗುತ್ತೆ. ಅದಕ್ಕೆ ನಾನು ಮಗಳನ್ನ ನೋಡ್ಕೊಳ್ತಾ ಇದೀನಿ. ಪೇಜ್ ನಂಬರ್ 66 to 73, I have ensured that I paid the school fees of my daughter. ಇಷ್ಟಾದ್ಮೇಲೆ, my lords, I'll stress my point only on 2F and 2S.
ಈಗ DV Act ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ದಾರೆ
ಅವರು? My lords, ಒಂದು, they have asked compensation of because saying that 2 lakh ಆಮೇಲೆ shared household ಇದೆ. shared household ಇರ್ಲೇ ಇಲ್ಲ. The 2S demolishes, 2F Act demolishes. Domestic relationship ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ this domestic relationship is very very important point for me for this reason. Live or have at any point of time live together in a shared household ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ that doesn't mean at any point of time, doesn't mean at any point of time in the distant past. My lords, at any point of time only applies, my lords, where the aggrieved person left the household temporarily and her belongings are there in that household, and also not where she established her own residence. My lords, in that, my lords may come to page number 98 of their own petition. Non-petitionally, page number 98 ali, she has mentioned that she has admitted position that she has left the household in 2008. In 2000, my lords, in page number 100, my lord, she says that 2022 only one sale deed miss agide. Adu adrullu sulu helidare. Absolute property anta ಹೇಳಿ, absolute owner of the property. No,
which not. Property?
The property which she is claiming now that I have forged, it is not an absolute owner. She is not an absolute owner of the property. Back then she was only 19 years old. It is a joint name.
Aithu joint name.
And one, my lords, one incongruous statement is this one, my lords. First statement, number 1, she admits in page number 98 that she was subjected to domestic violence by the petitioner during the cohabitation under 2004 to 2008. The very next statement, she says that she approached the respondent therein and the petitioner herein for a property dispute. And she says that she found out that I forged the property and now she wants the property back. This is what she is claiming. My lords, if really the domestic violence happened in 2008, abuser, very same abuser after 14 years later, that shows, my lords, her statement itself is self-contradictory.
Right. Objection ಆಗ್ತೀರಾ?
Please, my lords, I'll file my objections.
And in this regard, my lords, there is no judgment
There
which would,
is a judgment straight away to the point which I can.
I also can provide, my lords.
Point versus point?
It's on
Yes, my lord.
limitation.
Please. My lords,
Limitation.
I am not even
Yan limitation?
stressing my point on 468.
What limitation?
Not the only point they're raising is after 17 years, whether I can initiate a DB.
What were you doing for 17 years?
But
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ sir?
not that I have to,
You have to seek instructions what she was doing for 17 years. ಅವ್ರೇನೋ ಹೇಳಿದ್ರಲ್ಲ.
not that is false. Not 2005, I give a birth to a daughter and what they say is, and he is a person who is the brother-in-law is the friend of the petitioner. And he is a person who gets performance of the marriage with my sister. 2005, I give a birth to a daughter and now he says 2007, not I had so and so relation.
ಮಗು ನೋಡ್ಕೊಂತಾ ಇದಾರೆ ಅವ್ರು.
But immediately after 1 year or 2 years to make allegation that I had such a relationship, not, it's a time of it's a false statement.
She never contacted me until 2022, my lords. 25, so 25, after 25, if she got to know, let us assume even that worst case on me that I have forged a sale deed. 25 tanka yakadru innu 3 varsha.
One para may cite.
She was waiting for some kind of settlement from me.
Sir, judgments are written on the facts of the
Yes,
case.
Certainly.
Not, we can't blindly follow a judgment.
Not, there are two judgments. One says even after a divorce, the proceedings
No
is
problem.
maintainable.
No
Even
problem.
after judicial separation, it's maintainable.
No
But, sir,
problem.
I will file my detailed objections. along
Please
with
do file. Heard the learned counsel Chiranjeevi appearing for the petitioner and learned counsel Saravana who undertakes to enter appearance for the respondent wife. The issue crops up on a proceeding instituted by the wife invoking the provisions of the Domestic Violence Act 2005. Learned counsel for the petitioner would demonstrate before this court on the strength of the documents appended to the petition that the wife leaves the husband and stays apart from 2008, which would be 17 years prior to the institution of the proceedings. The institution of the proceedings under the Domestic Violence Act is on the score that the petitioner husband has forged or impersonated the wife and secured a release deed from the hands of got a release deed registered before the jurisdictional sub-registrar. It is, the event has happened in the year 2022. The jurisdiction of the domestic violence court is invoked in the year 2025. Apart from the fact that the learned counsel for the petitioner also submits that a crime is also registered against the petitioner for the very same reason of forgery or impersonation, which is pending. Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ. ಮಾಡಿದ್ವಿ, we'll withdraw again and file fresh.
In which a charge sheet is said to have been filed, be that as it may, in the light of the aforesaid circumstances, there shall be an interim order of stay of all further proceedings before the concerned court till the next date of hearing. List the matter on 21st July in the fresh matters list. Objections, if any, by the respondent by then. Yes.
That's maintenance 5,000 is awarded. That
The learned counsel submits maintenance of rupees 5,000 is awarded by the concerned court. The said maintenance also shall remain stayed. Yes.
Grateful.
17 ವರ್ಷ ಅವ್ರು ಮೇಂಟೈನಿಂಗ್ yourself like 5,000 ಬೇಕಾ?
property out.
Oh, ಪರವಾಗಿಲ್ಲ. 5,000 rupees property na?
Property.
Yes.